Hello and good day everyone. This is to warmly welcome you to the 14th edition of Legal Insight. Today is Saturday, the 9th day of May 2026. In this edition of the program, we are going to continue our discussion on incorporated companies, and the focus will be on quorum for meetings. Now, what is a quorum? A quorum is minimum number of persons required to transact a business, either at the general meeting or meeting of the board of directors. Before proceeding to discuss the quorum in relation to general meeting, it is important to state that generally, it is the articles of association of a company that determines a quorum for meeting of the company or the meeting of board of directors of the company. It is only in a situation where the articles of association are silent or where the article has no provision in relation to quorum that the provisions of Companies and Allied Matters Act CAMA 2020 will be applied. Our discussion will be based on the assumption that a company has no provision in relation to quorum in its article of association. Now, for the purpose of annual general meeting or extraordinary general meeting, the quorum is 1/3 of the members or shareholders. Now, where a company, for instance, has 15 members or shareholders, the quorum for the general meeting of the company will be 5. However, in a situation whereby the number of shareholders or members of the company is not in multiple of 3, the number that will be considered to be the quorum of the company is the number that is nearest to 1/3. For instance, a company having 31 members, the number that will form the quorum is 10 because it is the 10 that is nearest to 1/3 of 31. Let us consider a situation where a general meeting of a company has been called, quorum formed, and a meeting commences. However, along the line, a member or shareholder withdraws from the meeting. In that case, if it appears to the chairman that the withdrawal was due to insufficient reasons, and for the purpose of reducing quorum of the meeting, the law provides that the meeting will continue, and any decision taken will be binding on all the shareholders, including the member that withdrew from the meeting. However, in a situation whereby at the beginning of a meeting there was quorum and subsequently there is no quorum due to some members leaving the meeting, if it appears to the chairman that the shareholders or members left the meeting due to sufficient reasons, then the meeting will be adjourned for a period of 1 week to be held at the same time and place. And if at the adjourned date there is still no quorum, then the members present will be considered to be the quorum, and any decision taken will be binding on all the shareholders. For the purpose of meeting of the board of directors, the quorum is 2 if the number of directors is less than 6. Where, however, the number of directors is 6 and above, the quorum will be 1/3 of the number of directors. For instance, a company having 9 directors, the quorum will be 3. Where, however, the number of directors is not in multiple of 3, then the quorum will be a number that is nearest to 1/3. For instance, a company having 16 directors, the quorum will be 5 because it is the number that is nearest to 1/3 of 16. Now, what happens in a situation whereby the board of directors cannot form quorum for the purpose of transacting any of its business? Will the company stay idle, or will the board stay idle without acting? No. The law has provided a solution, and the solution is that the general meeting of the company will now act in place of the board of directors. In conclusion, it is important to state that any decision taken at a meeting without necessary quorum is a nullity. Therefore, it is important that whenever a meeting of the company will be held, the quorum must be confirmed before proceeding to transact the business of the day. This brings us to the conclusion of this edition of Legal Insight. Thank you for watching and see you next week.